What the British did here, they did in Australia, they did it in North America, they did it in South Africa. The notion that communities do not own land, because the concept of ownership under British law is private ownership. And therefore they don't understand how a whole community can own. And that if a community owns, they think that individuals have no rights against the community. What we had here was a situation where communities were themselves juridical persons and therefore controlled definite territories, determined access to land in those territories, the functions for which that access could be given, and the manner in which property rights were allocated, transferred, redistributed, or otherwise transmitted to future generations. And one of the most important aspects of community land law or indigenous land law is that it protected the rights of the unborn as well as the rights of those who are living. And this is why property could not be sold or transferred outside the group. It could be sold or transferred within the group, but not outside the group, because if you transferred it outside the group, you would be expropriating the rights of future generations, and therefore they would not have no sustainable basis for livelihood for that reason. And therefore it was a very developed system of land law. The British, of course, could not accept that. If they accepted that, they would not have had the power to allocate land, quote, legally. And therefore the first thing they did was to say, these people don't understand what ownership is. Secondly, they are not capable of controlling land directly. And thirdly, they don't have the technology to develop it. And therefore, we are going to expropriate title, give it to settlers, pass laws that would enable the settlers to develop it whichever way they wanted it. And the way they dealt with occupation of communities or indigenous communities in areas that they did not need for purposes of settlement, they put them under trust, because they argued that the natives could not hold land as juridical persons, so they put them under trust. And the trust concept continued up to independence. And in this country now, land which is not registered in individual names is held by county councils as trustees, and that comes from the colonial concept that communities cannot hold land directly. So the notion that ownership means total and exclusive expropriation of all right to land is not one that's known to indigenous law. Indigenous law will allow people to graze on it, others will build on it, others will cultivate it, others will transit over it, and all that is managed through a community hierarchy that starts from the family to the lineage and then to a wider territorial body. So there were very, very clear rights. But you see, you are not going to find that in the literature, because the British did not even bother to find out how this was done. They simply assumed that we do not see a sovereign, we don't see private property, we don't see land registries, and therefore these people do not know anything about ownership.